All right, everyone, we are live. Welcome to this week's edition of IMMpact Litigation. I want to thank everybody for coming, and remember that you can post your comments, and we will take them as you post them. So, but first, we're going to start with the update of what's going on. So, let's start with I think Aaron's having problems there. So let's start with you, Chuck. Why don't you give us an update on, tell us what's going on first with the 01 cases.
All right. The 01 case, of course, is now, the original 01 case is settled. All of the Tate plaintiffs received their visas and entered the United States. We did not get enough new clients for a new 01 suit, so we were taking ones to the 7 people that signed up. If you'd like individual cases, you can contact any of our firms, and we're happy to assist you on an individual case. We're actually doing that for a couple people right now. I also want to update you on Fong, our EB5 case. We are submitting our reply brief on the preliminary injunction this evening. One thing we did find out, Jeff, you'll find this particularly interesting. We were digging through the local rules for the judge assigned to us. He is the only judge in the District of California who doesn't allow Zoom hearings.
Oh.
So we will be going to LA on June 14th for our hearing. That is neither in his individual court rules, nor is it in his memo they send out on cases. It's actually on the internet site. So Danielle found out today, so I'll be going to LA for the argument on June 14th. I think our reply brief is excellent. It'll be filed tonight. And we will send around copies of both the government reply brief, which I found to be wildly, not only inaccurate, but inadequate, along with our reply brief for the PI. And we'll go from there. So that's the update on the O's and Fong as of right now. And I see that Aaron Hall has returned.
Aaron, welcome back. What's going on? Well, a lot's going on with Mr. Doe, but tell us what's going on with the Doe case.
With the Go case, we have our opposition to the motion to dismiss and our motion for summary judgment, both due a week from yesterday, so June 7th. So we are working on that, and that's the update there.
All right.
Can I interrupt to ask if anybody has those banners so we can throw up if folks want to watch the video after so they can easily find which case we're talking about?
All right, that's a great idea. I will do that right now.
Yeah, for doing that. As you can tell, I'm in my office today. By the what the heck is that background? We're visiting in Utah this weekend. So.
Oh, how fun visiting family.
Nice.
Good. Well, I'll give you the update on Milligan. Milligan, as you recall, we received the government's motion to dismiss, and last week we filed our response to the motion to dismiss. Now the government has the opportunity to submit a reply, and then the judge will render a decision. So, keep posted for that. In an interesting move today, the U.S. attorney actually reached out to us and asked us for some identifying information for various plaintiffs, including case numbers and dates of birth. So,
was that just for Kinsley or for Milligan also?
Oh, was that just for Kinsley?
Yes,
the list I saw was for Kinsley.
Oh, okay.
That was the Kinsley case.
Okay, got it. Okay, so that's interesting, though, because that shows movement on the Kinsley case. So let's talk about that then. Any updates on Kinsley?
So exactly as you just said, the government has reached out and asked for dates of birth only for a few of you. So a few of you will get an email from Gracie Roper, our awesome new admin, this evening or tomorrow. If you don't get an email from her, it's okay. It means we don't need anything from you right now. Please don't panic. But the government has asked us to confirm case numbers and dates of birth for a couple of the non-immigrant, non-K visa cases. Not sure
Good
why.
sign.
Yeah, that's a good sign. And then
they already have the full list of plaintiffs and everybody's numbers. So maybe these were folks that they had trouble finding through their numbers and needed to confirm dates of birth. Not sure.
Yeah, we'll see. But that's good news. And then the other update is that Zach is working as we speak on the motion for summary judgment. And so we anticipate filing that probably next week by the time we give it several layers of review. probably sometime next week that we'll file that.
And for folks, some of the Kinsley plaintiffs has been asking me kind of what's the difference between a motion for summary judgment versus a preliminary injunction, and sort of what's going into that. So I've been explaining to folks, summary judgment, preliminary injunction is, please do what we're asking temporarily while the lawsuit continues, whereas the summary judgment is, we don't have anything to argue about in terms of the facts. We want a final decision on the lawsuit, and we want a final decision now, please, given that we all agree about what the facts are. We're just disagreeing about the law. Was that a good summary of the difference?
Perfect summary. And I would add, too, that the preliminary injunctions are harder to get because you really don't have discovery in the case. You're asking the judge to kind of find that you're going to win at the beginning of the case. And you have to show irreparable harm. So that's an added component that we don't have to show for summary judgment. So if we have a good case that we think we're going to win, we sometimes move for summary judgment very quickly because it's better than a preliminary injunction.
So for Kinsley, we're seeing a lot of movement. A lot of you have already let us know that you've gotten your visas, that you've come to the U.S., or that you've had appointments scheduled. Of course, we're aware that that's not the case for everyone, and that some of you are still waiting. Because even though many categories of visas are now have national interest exceptions, some do not. And some who do have national interest exceptions, still their consulates are just not moving quickly for whatever reason.
Hey, Jeff, I'd like to go for a second. Can you put a Go banner for us? Just talk about Go for a second. We received, I think it's almost 900 pages of a record from the government counsel in this case. As we've been going through this record, what's really interesting in Go banner is that the government paid very little attention over the course of the last really 2 years, 3 years almost, 2 DV lottery cases. To me, that's extraordinary evidence of one of their statutory responsibility to visas that they know disappear every year, so they refuse to give priority. And even as they formulated this year's their new 4 priority system, basically putting DV lotteries at the bottom, I think goes to the strength of our claim in going to Judge Mehta and showing him that the government, one, ignored him in Gomez. They're ignoring him now, and worse, they likely intend to ignore a future lawsuit, DV 2022. So all these people that have won DV 2022, they're going to have problems going forward because clearly the State Department has no intention of issuing all 55,000 visas next year either without a court order. So I think the power of the Go lawsuit is in these documents which we received. We will, once we finish reviewing them and file our motion for summary judgment, we will make sure that's public. Everybody can take a look at that, and likely work through AILA to make that happen. Is that a pretty good summary, Aaron?
Yeah, you got it. The admin record really makes it clear what's happened, and it's actually no secret. Like Lily was describing, what the difference between summary judgment and other types of motions. I don't think there's going to be any factual disputes here. They've decided it's not important to them, that they think they have the authority to say, actually, we're basically not going to issue anywhere near the number of visas that Congress allotted, and they think that's okay, and we don't. Yeah. And the judge will make the decision there.
Now, just to remind people, in the Gomez case, which of course is DV 2020, there has been no movement, there has been no hearing date set, and I'm going to tell you, let's not be surprised if the hearing is the same day. I mean, that's kind of where we are on the DV 2020 case. But I thought it was really important to get that piece of information out there, given where we are. And Jeff, can you put Annunziato? Because we haven't touched on Annunziato yet. Because, Aaron, we had some news about that in Annunziato, haven't we, the last few days?
Yeah, around the time the government was filing their reply in support of their motion to dismiss, they reached out to us and wanted yet another update on the status of the remaining plaintiffs there. And to remind you, the remaining plaintiffs in Annunziato are just employment-based and family-based people. And following that, within the last week or so, we've heard a lot of movement on our clients' cases in Annunziato. We have, I think, probably 5 or 6 people who've either been scheduled for interviews, or they have been contacted out of the blue by the consulate saying, we're trying to process your case. We need X or Y document, or we need you to do X or Y thing after 6 months, a year of radio silence. So it looks like some movement out of the Annunziato case, and they may be trying to be able to show a straight face in front of Judge Seaborg on June 10th when the hearing is on the motion to dismiss. I think they want to look good by saying, look at all the stuff we're doing.
I know they're worried they're going to lose that case, and they don't want to set precedent, so they want to move everybody out. So that was really important. That hearing is coming up. That hearing is by Zoom, so that will make sure that everybody has access to that wants to listen in. But as far as the phone case in EB5, sorry, that will not be on Zoom, because apparently that judge doesn't do Zoom. So all you Fong EB5, just stay tuned. I won't live tweet it since I will be arguing, but I will make sure we update everybody that hearing is over on June 14th.
All right, and what about all the various consulates? I'll give you an update here. So we have sued Manila, Rio, Cairo twice. We've sued Cairo. And so what I want to tell you is that all of those.
Don't forget Moscow.
In Moscow, that's right. K1 against Moscow is the latest, and we were onboarding for London, but didn't get enough plaintiffs at the moment. June 4th.
Whoa! We are
the update, right?
Before anybody freaks out, we are well on our way for London.
Okay,
we're in the middle. We're going to be okay on that case.
All right,
we've got almost 70, so before all the London folks freak out, we're on our way. We've got almost 70, so I'm looking to go forward with that one if we can get a few more on. This Friday, June 4th.
June 4th at what time?
I think we'll be okay on that.
So we only need 30 more plaintiffs to file the London case, and we can definitely get there by Friday. So I won't give an update on that, other than to say keep promoting it and keep telling your friends, your K1 friends, to join it on social media.
Billy Blossom says you'll have another London tomorrow. Awesome. We'll see you tomorrow.
There you go. So as far as the other consulates go, we filed all those right around the same time. And right after we filed the first of those lawsuits, we received notification from the Department of State that they're no longer going to settle those cases, and that they've been instructed by their boss, the Department of State, to file motions to dismiss in every case. And even further, the Department of State headquarters has drafted a template motion to dismiss, which means that we will be seeing the same arguments in all of those cases. So what that means for you is that there's not going to really be an update until 60 days from now when we receive the motion to dismiss. That being said, like in all of our other cases, delay is to your advantage because it gives the government time to clear your case before the motion to dismiss to make them look good. And we are seeing that in all of these cases, except for Manila. Manila is not moving, but the other cases we are seeing people get scheduled for interview even though we're waiting that 60 days. So that's the update on the consulates, unless everyone has anything to add.
Can I just say something about?
Oh, sorry, Greg. Go ahead.
I was just going to say something about Manila. So, obviously we have that separate case with Manila, and we also have a bunch of Milligan plaintiffs still in Manila, and that is the one that we are looking to actually get to a judge because that consulate has been obstinate in both those cases. So, that's the exception to what you just said, and that's probably for people that are in Manila. Unfortunately, I think the way things are going, it's going to take getting to the judge and having these arguments before we see anything happening out of that consulate, unless something happens in Washington where they force their hand, which hasn't happened yet.
A quick follow-up on Moscow. The government has been served. We've confirmed service with them, so we're now waiting for their entry of counsel. I actually got to town this week. I'll be back on Friday. I'm going to call the person in charge of the attorneys at the on Friday to see if they're going to assign somebody sooner rather than later in that case. There has been an interesting trend that the same government attorney keeps getting assigned to our cases. So that's not a bad thing. We like working with that government lawyer, and it makes it easier to reach out to him, but it doesn't mean that he's inundated with a lot of different lawsuits. So we'll see what happens there, and we're going to move forward.
All right. Any other? Well, why don't we talk about DV 2021? I'm sorry, not DV 21. The EB case for 2021. Greg, you want to talk about what the case we're contemplating? Kind of what the legal theory is?
Yeah.
What our detractors are saying about us? All of those things.
You're talking about the AOS case, not the DV case.
Yeah, it's like we're not used to having this kind of like level of discourse, I should say. But the case is something I think is an important one. As folks know that are processing employment-based.
Hold on, Greg. Jeff, can you put up a banner that says AOS lawsuit so that people know where to be on the video? There we go. This way it's searchable when folks come up to the video later on. There we go.
All right. So here's the problem that we're trying to solve. In the Trump administration, when they banned immigrant visas last year and COVID came and there was general slowdowns at the consulates, the consequence of that was that family green card cases basically were halted for 2020, and it's still largely ongoing. Most family immigration cases are processed at consulates. Most employment cases are processed within the United States. Well, the way the system works is when numbers are not used in a fiscal year, and the government's fiscal year is October 1st to September 30th, if they're not used, say, in the family categories, they roll over the next year into the employment categories. If they're not used in the employment categories, they roll over the next year to the family categories. And if they're not used in diversity visa, they just go away. And we've litigated the issue of the diversity visas already with some success. And we're in the middle of that. But it sort of gave us an introduction to this concept of basically the Trump administration brought us, which was you can basically reduce legal immigration to the United States by delay, even if you can't get Congress to change the law. So basically what's happened is last year in October, we had, 100,000, 120,000. I don't know if we actually saw the exact numbers that rolled over. Yeah, Chuck, you're muted. But anyway, the numbers rolled over.
It was 128,000 that ran over, I believe.
Okay, so we had 128,000 numbers that rolled over to employment-based, and most of the backlog on the employment side that they were clearing up because EB2 and EB3 were current for rest of world. So most of the people that benefited from that were Chinese and Indian nationals who were facing backlogs that were as long as the eye can see. But the problem is that that those numbers are not permanently rolled over. If they're not used in the fiscal year that they've rolled over, they roll back the next year, back to the family category in this case, or vice versa, depending on where they rolled over. And the problem is, and this is the one that caused a lot of confusion. It caused me a lot of confusion. I know that we were sort of like had to go really talk amongst a lot of immigration lawyers because this is all unprecedented. It's never happened before. So we were trying to figure out what exactly happens when these numbers roll back to family. And if they roll back to family and the numbers get used, then it's not an easy case to make that you should basically, for lack of, excuse my French, the screwing over family a second time. But that's not what actually happens. The way the family immigration numbers work is they're in two buckets. One bucket are immediate relatives. These are spouses of U.S. citizens, parents of U.S. citizens, and minor children of U.S. citizens. They have no limits on the number of green cards that they get. The family preference categories, which are similar in some respects to the employment-based preference categories, each one of those categories has a set number. And altogether, it's 480,000 that are in the family-based categories, which seems like a lot, but the way it works is that because employment, I mean, the immediate relatives don't have any limits, they could basically and they go first. They could gobble up essentially that 480,000, which is actually what happens every year, is that there's more than 480,000 immediate relative cases that are used. So family-based, they don't get screwed. They get 260,000, I believe, that are a floor on the number of family-based numbers that happen every year. So basically, because they get immediate relatives use up all the numbers, it's always 260,000 for family-based. So if this 120,000 employment-based rolls back over to family, because of the way it works, they're still going to get 260,000. They're not going to get 260,000 plus all these numbers that rolled over. All those numbers are going to ended up going to immediate relatives who don't have limits anyway. So what's essentially happening, this is the way you need to think about it, is there is a net decrease that's going to happen of probably 100,000 or more green cards from the system from what would be done had nothing happened and all the visas were processed the way it would before. There would have been about 100,000 more green cards that would have been issued overall. So we are going to argue for two things. One in this case is it's a mandamus case. We are going to try and get everybody adjudicated, at least our plaintiffs, adjudicated before September 30th, so they have their green cards and they will get those numbers. We are also going to seek a remedy similar to what we saw in the Acker and Gomez cases, where we're going to ask a judge to reserve visas that, rather than letting them roll back and getting wasted, to reserve those visas, because that's what Congress, when they created this law 20 years ago, that created this rollover system, Congress wanted to maximize the number of green cards that were going to be issued. Before the law changed 20 years ago, all those numbers got wasted with they didn't get used. And now when you hear about legislation to recapture visas, for example, for doctors or physical therapists or nurses on there, that sometimes we hear about this concept of recapture. That's what they're talking about, is these old numbers from 20 years ago before the rules changed and allowed for the rollovers to happen every year. So we're going to ask for that. So that would hopefully benefit everybody. There have been some naysayers about whether this case actually makes sense or not and I'm not going to mention the other law firm on there, but we obviously we wouldn't be taking on this case if we didn't think that it was worth the fight. But we also think that this is a very unprecedented situation. We've never had a rollover of anything like this. It's very clearly contrary to what Congress intended when they changed the law on this. And what we know from the other case that we had, that if a judge is motivated to try and fix a wrong on there, and in this case, it's I think it's more neglect with the Biden administration than any deliberate intention to wrong all these people, that a judge has the ability to craft a remedy that would solve this problem. So we're certainly going to seek that. And frankly, for a lot of the naysayers, we're willing to take this fight on. There's not much of a downside if we don't, if you don't want to participate in it, you don't have to. And if we lose this, we're going to be in the situation that we're going to be facing anyway in September. So we think that if we're successful, there's a big upside, and if we're unsuccessful, we're basically in the same place we're going to be in September.
I just want to jump in and add that at 2:00 Central, 3:00 Eastern tomorrow, Greg and probably our colleague James and I will be doing a Facebook Live specifically answering all of your questions about this suit, because we know this is a complex one. It's really different from the other ones we've done against the State Department. So I will step back for now, but I'm sure there'll be a lot more questions and answers that we won't be able to get to tonight, but we'll be on Facebook tomorrow, and that'll be also available afterwards if you're not able to make it at that specific time.
Yeah, I mean, I was just going to add that one of the reasons that I think this lawsuit is important is, you just heard Greg explain 50 years of immigration history in the visa bulletin. It hasn't been changed since it was created. Like, these numbers have never been changed, and no one knows how they work. I mean, Greg knows how they work because he's been researching it for the past 2 weeks, right? But even before then, none of us knew how it worked, right? I mean, we can admit that. And so part of the advantage of this lawsuit is it's going to shine and put attention on this huge problem.
Yeah.
That's why we haven't increased the numbers. Courts are now going to be aware of it, and hopefully Congress will be aware of it.
Well, and the Biden administration will be aware of it as well. I mean, I think that it's important to file this suit just to shine light on this problem alone. I mean, obviously we want to win, but to the extent that the administration can ignore this, I think that's a win also.
Yeah, and we've often seen, in situations like this, Congress pass emergency legislation to fix the issue. So that's another way that this could get resolved.
The other key thing that comes out of this is if nobody does anything, and USCIS just continues to hobble along and get to cases when they feel like it, that means people that are waiting to apply for their adjustments now because the priority dates are in the visa bulletin will continue to wait. But if USCIS is forced to use all available numbers as part of this process, that means the visa bulletin itself will move faster, and the massive backlog that's faced by Indian nationals and Chinese nationals is seriously wiped out, because this lawsuit is not just about this year, it's also about next year, because an even larger number of family-based numbers flipped over to employment-based cases for next year. So unless we get this fixed now, we're going to lose probably close to 300,000 employment-based visas that would have wiped out more than 50% of the backlog for EB2 and EB3. That's why this looks so important.
One other thing to add on to what Chuck is saying, if you actually look at the processing time charts at the different service centers that are handling employment-based adjustment cases and the National Benefit Center, some of them are reporting like taking several years, like over 3 years, to process these cases. Well, what's going to happen is we lose this group in September. We lose all of next year's numbers in September 30th, 2022, which means that a lot of people, I think, who are saying, well, it's like, well, I'll be a free rider. I mean, I don't need to sue because I'll get, if I filed this year, I'll just get next year's numbers. You may not get next year's numbers either on there. It's possible that all of the, and obviously people that are filing next year, unfortunately, I think that they're really in a tricky spot. But once the COVID numbers start to get back to normal on there and processing gets back to normal, it's very possible that these cases will not be worked, and all of the 200 some odd thousand numbers that roll over between last year's numbers and the coming year's numbers, that none of them will actually get used, and it will be a net loss of all of those numbers for green card totals in the system.
So
The
what
key
we're
to
asking the
remember
judge
here
to do.
is that the USCIS has no plan. They're just like the Department of State. They have no plan to get caught up. They don't. They're just going to keep doing what they've been doing during the Trump years and delay and delay. So until their feet are held to the fire, they're not going to move. They're just not. I think that's quite clear from their history.
So this is different from a general mandamus case where we're saying this is taking too long, and it's sort of more similar in some ways to the DV 2020 and 2021 cases.
But
we
are going to argue mandamus. We're going to argue a delay, make a delay,
right?
Well, because
but
12
we're
months
not.
It should never take 12 months for an immigration process. That's the other thing we're trying to call attention to, is how ridiculous these waits are overall on there. Aside from, I mean, it has this horrible consequence at the end of 12 months, but it shouldn't have taken 12 months in the first place.
So what we're asking the judge to do is either get all of these cases adjudicated by the end of the fiscal year, September 30th, so everyone whose priority dates either are current or should become current by the end of the year. So anyone who filed last October, November, December, when the visa bulletin moved, the filing dates chart is based on what their estimate is for the fiscal year. So those, even if they're not current now, they should be current by the end of the year. So we're asking the judge to order USCIS to adjudicate all those cases by the end of September. Or if the judge doesn't think that's realistic, to do what they've done in our DV cases, which is make a special order to hold those numbers over. Don't let them disappear as they otherwise would, so that even if those cases take more than 12 months, they still get adjudicated without those numbers just disappearing and adding to the backlog for everyone. So as all of us have said, this is an unusual case. It's not just a regular USCIS takes too long for green cards case, which the courts have had sort of mixed outcomes on. But this is a special situation where USCIS is being negligent with respect to the backlog that especially affects Indians and also Chinese folks. So should we summarize who's eligible to join that suit? I linked in the comments, I put a link to our FAQ, so there's a lot more information there, but should we just give a summary of who's eligible to join this one?
Yeah, it's a great idea. Thank you.
So these are folks who filed your employment-based, most people would be EB2 or EB3. Do we decide EB1 can join as well if they're backlogged? Cases either during that period last fall where the visa bulletin moved forward in October, November, and a few in December, or folks who already had your case pending at that time and you were waiting in the backlog, either from India or China, or one of the other backlogged countries in your category, because everyone will be affected if these numbers aren't used this year and they're added to the backlog.
Yeah, I should say, Lil, you kind of hinted at it a second ago as well. We had regarding the question we've had from a few folks about, well, what if my final action date isn't current yet? Mm-hmm. And we are including those folks because, as far as we know at this point, the State Department has not been inaccurate in their estimates of where they are. So in October, when they issued the filing date chart and they said, these are the cases we're going to take, that's a forecast for where they think they're going to be in September of the fiscal year, the last month of the fiscal year. They believe, and it's always it's kind of hit or miss as far as whether they're going to be there or not, because, for example, they don't know if people are no longer going to pursue a green card based on an I-140 that was approved 10 years ago. They don't know how many family members are going to be part of that petition. There's a lot of things that they don't know. So they make this forecast, and State Department's pretty good at making these forecasts. They've been doing them forever on there. And sometimes they guess a little high, sometimes they guess a little low, but that's how they came up with those dates. They didn't just grab them out of thin air. And at some point we would have expected, if they were like wildly off, to get something after all the receipts were in, and it took 6 months for all these cases to be receipted. But we would have had some kind of indication that they were really overestimated or underestimated. If they underestimated, we probably would have seen another attempt to change the filing date charts, maybe. If they had overestimated, we probably would have heard some kind of statement at this point. So we are working on the assumption that the State Department was relatively close in their numbers, and that these are folks that should have had their cases worked by the end of the year, had the USCIS been doing their job. So that we did that. We decided that, initially we took a really narrow approach and just said October, November filers, and then actually it was one of my law partners who pointed out that we have cases pending for people that filed earlier than that are going to be depending on these numbers that have rolled over as well. Why are they not included? And it's like, you're right. They should have been included. So we look, we considered that, and then also we're reminded, and I was just completely negligent in this respect, that the December filers as well were filing. I had thought it had ended in November. I forgot that it had gone through December. So that was just a basic error on my part. But so that's why we had expanded the pool of people that can apply. And we're leaving this open until June 21st because actually waiting a little bit longer is going to make it a stronger mandamus case as opposed to filing right now. So we will, we don't want it to be at the end where there's not enough time to work on it, but we don't want it to be so early that the government comes back and says, it says it's not unreasonable yet on there. So it's a balancing act to figure out when exactly we're going to file, and that affected as well how long. So we're keeping it open a little bit longer than we normally would. So it'll be June 21st. That is the plan for when we're closing out taking plaintiffs.
And as a follow-up on that, part of what we're going to file is the complaint shortly thereafter. But we're going to go for a preliminary injunction in this case. because of the timeline. So we're not going to wait the 60 days because of the end of the year numbers that we're looking at. But that still will give the government a couple months to get work done. But it'll be important to pursue the immediate because we can show the irreparable harm here in the loss of these numbers, just like we did in the Gomez cases. Jeff, there's one other item I want to talk about, and that is if you put this up, the H-1B case. This is the H-1B lottery would be the better for this. And the human society. I love the rule. Thank you, Jeff. This is in regards to lottery. You know, this year the USA has received a record number of lottery applications from employers with 300 and X thousand visas. Nowhere near the actual number of people that would actually get H-1Bs this year. And what happened, and we've discovered this through some work that we've been doing and folks that have approached us, is that there are a lot of people.
Wait. The Humane Society, no,
Yeah,
there's
this
two
is-
H-1B cases.
You,
Talking
no,
about the onboarding.
they got the wrong one.
Not Humane Society is the other case, which is already filed.
Yeah, this is the H-1B lottery rule.
Right.
So the H-1B lottery, a lot of people basically use front companies to just sponsor them, and people filed 6, 7, 10, 12 different lottery applications. That appears to be a direct violation of the rules, where it says that the USCIS is supposed to count the individual foreign national in the application, not the applications themselves. And of course, USCIS does not allow the same employer to submit multiple applications. Why does it allow people to submit multiple applications from different employers? Now, if it was just, people submitting with 2 employers, that's one thing. But there appear to be a lot of people that filed 10 employers or 11 employers, and that those jobs aren't real jobs. They are jobs. There are companies that say, "Oh, we got your visa, now go find a job," and that clearly is not the intent of the H-1B. And it also squeezed out a lot of what we're going to call legitimate H-1B visa seekers. That, like some others, are in the United States. They're on F1s, and they could not get the visa. So we have over 100 people that have now signed up for this litigation. We're going to begin drafting that complaint. And moving forward, there's still time to sign up. I don't recall what our deadline was on that, but we're going to keep it open for a little while longer for people to join until we're ready to file the application. It will be likely be filed at the end of next week, only because I'm out of town, and I'm going to be the lead on this one. But I want to know that we're going to go after the H-1B lottery rule because we think it's illegal. We think the counting of the same individual multiple times for multiple employers is contrary to the law as laid out by Congress when they allowed USCIS to process these applications. So just wanted to get that out there.
Chuck, I have a question for you. How do you think the Biden administration, particularly on our arguments about the illegal appointment of Chad Wolf to that job, how do you think that they are going to respond to that kind of argument? Because I can understand why they want to keep presidential power and all that. I mean, well, I don't really understand it, but that's the mode they're operating in. But how are they going to respond to that argument? That's the one I'm really curious about.
Well, that's a great question because they've never confronted it before. It's literally never been argued anywhere before. They're obviously going to circle the wagons. That's what the government does. They always circle the wagons, even when it means hurting people, even when it means they're acting contrary, as we saw in a great article today that Greg sent us, even when they're contrary to Biden's own campaign promises. They're just circling the wagon. So I think they're just going to argue that, hey, we run the lottery. We put this out for notice and comment, and we can do whatever we want.
But do you think they're going to try and defend Chad Wolf's appointment?
They've certainly, what they've done on the appointment issue is they've had Mayorkas at least one time try to reaffirm what the Chadster did on at least one occasion, and they may do that here. Again, what they're trying to do is, I think, circle wagons and keep the government from losing, respect to courts, problems with how they follow regulations. And Maybe the same thing happens in the Biden administration in 3.5 years. And Biden gets kicked out, Newman's gone, he has somebody who hasn't been confirmed by a Republican Senate, and he starts issuing regulations. And maybe they're thinking, hey, we want our regs to hang around too. So, like you said, they're just out to protect themselves and their power, even though we might not understand why they do that when it hurts the people that they said they want to try to help. And there you go.
Somebody had asked about whether we're going to talk about the Eagle Act on this one. That's actually for our Facebook thing for tomorrow that Lily and I are on. So this is just litigation stuff we're talking about. We're not talking about like Congress and the other things. And I'm not going to be doing my Facebook tonight as usual. We're doing that tomorrow, and because of the kind of the rescheduling that's happening today. So I'll be talking about that tomorrow if anybody's here hoping to get information on that.
Well,
all right.
That's a great question you put up there.
Yeah. Forget about the Curtis Morrison part. But assuming there's this case, apparently there's a good luck case that was filed. If it gets first of all, one of the things we would want to know is did he say that it's a related case, right? And did he file a motion to consolidate? Because it's not automatic. So we don't know if it'll get consolidated or not. But assuming it does, and a judge orders a PI for consolidated cases, which plaintiffs would get more priority?
Well, first of all, I mean, you make a good point. Would they even be consolidated? I will tell you, we will fit any consolidation with our case because we are already on an expedited schedule for briefing. What the judge could do is just hold that case in abeyance. I just said, I'm going to hold that in abeyance until I make a decision on the Go case, because the Go case will have a impact on that case. Cases do not have to be consolidated. That does not have to happen, especially if it's still within the 60-day time frame. He also doesn't have to take the case at this point. But I would say that the Go plaintiffs, as lead plaintiffs in that matter, would likely get priority in whatever processing occurs. Now, keep in mind, if we compare this to the Gomez case, we had the Acker plaintiffs, the actual Gomez people, they only had 5 lottery people. They all got their visas. And in that case, we had 178 or something like that, and all but 12 got their visa. And the reason they didn't get their visas is because they couldn't get to Moscow. They just couldn't get to the consulate to get them. Otherwise, all of our plaintiffs would have gotten the visas. So, but you may remember that it was basically a free-for-all beyond that. And I suspect that may happen here, which is why being the lead plaintiffs in the lead case with your lawyers getting your cases processed is important. Victoria, thank you for your question.
A related question, Chuck, is what happens to the briefing schedule if they get consolidated? Because we have a hearing July 13th.
Yeah, I suspect that hearing will go forward and will not be changed. Another reason we will oppose any consolidations. I do not suspect that hearing date will change at all.
Time is
Keep in mind, if what Judge Maida said is he doesn't have anything the rest of the summer that's available. His rest of the summer is full with his other parts of his calendar. It's not his only case. He has dozens and probably hundreds of other cases. So that date's not going to change.
Okay, we have already addressed this, but he's going to file June 6th. Apparently, we don't communicate with Curtis about these cases. We're not
about his practice. That's his practice on our practice. So we
don't know anything. All right, let's see. Good news from a Go plaintiff. Finally got consular appointment in Buenos Aires. Can't schedule the ASC appointment. Anyone know anything about ASC in Buenos Aires?
Well, as far as our race, you have to reach out to the consulate, the IV section, and ask for the appointment time. Beyond that, I don't have any specific information about any consulate, but go to their website, see what the ASC says, email the consulate's immigrant visa chief, find out where they would set that appointment. This is where having your own lawyer is important on your individual case once you get that appointment set, because you can get that lawyer and have your lawyer work to make that happen.
All right. After we filed Kinsley, the embassy in London announced that they've resumed immigrant and K-1s. What effect will it have on the judge's ruling since they already are claiming to be processing them? Well, I do know we got two, what was it, Greg? 2 K1s from London today approved. So I think they are processing them. I mean,
Yeah, they are processing. I think the problem, Jeff, is they are woefully behind.
yeah,
They
I
are
mean, they're
so,
delayed.
and they're clearly not doing on their purported first in, first out. That's
Mhm.
also clearly not happening. So, the ruling here is to seek them to issue these older visas and the newer visas in the order they receive them, and to make sure they're doing them. Because remember, K1s are not first priority; they are second priority for the consul, and only because we won the Milligan case. I mean, that's why they're there. So again, this is to make sure they get your case processed, which is why you want to be a plaintiff in that lawsuit.
Right. And as usual, the judge is looking at individual cases now because we're at this point where we're at motion to dismiss and summary judgment. So the judge kind of has to decide this point, is it really an unreasonable delay for individual cases? And if he decides it is, you're going to get an order saying this case is unreasonably delayed, and he's probably going to give the consulate a specific period of time under which they have to make a decision one way or the other. That's if we win. Okay. Let's see. Michael Fallison, yes, I sent your case individually to the consulate in to the AUSA. I don't think he'll give me a response. If anything happens, you will find out about it. But again, Manila we're not seeing any movement for anyone, even expedites in Manila. So that's unfortunate news. All right, let's see. Consulate in Latvia made several case transfer requests to KCC. They keep ignoring the embassy. Sent us proof of that today. Aaron, I assume you're getting that.
We got that. We got that email. Thank you very much, George. It's really remarkable. Here you have the consulate say, yeah, we'll do your case. No problem at all. And the KCC, this is actually great evidence for us because some of the things that the government said about the KCC, I think is getting told a bucket full of bull about what the KCC is doing or not doing.
Okay. Let's see. What is the game plan for consular cases after they file the motion to dismiss? What can you expect to see? Same as what you're seeing now, right? You're going to see movement on particular cases. We did get an approval out of Rio today. So Rio is moving. So, if the motion to dismiss doesn't stop or start processing, it's just a motion that's filed in the middle of the case.
So motion, I've seen this question, and I think I answered it for Ms. Ponomarenko, but I've gotten this question from a number of plaintiffs. Motion just means request, right? It doesn't mean the State Department is dismissing the case. Only the judge can dismiss the case. It's just the State Department through their government lawyer saying, we don't think this case is legitimate, please judge, throw it out, right? So the judge considers that, and we fight it, and we filed the response to the motion to dismiss in Milligan, I believe, and as we get similar motions in other cases, we will be fighting them in other cases. So exactly as Jeff says, the case continues. I think a lot of people say, oh, the government's requesting to dismiss our case. Does that mean we can't sue anymore? No, it's just a normal part of the lawsuit.
Okay, so Chuck, you've got Chuck jumped off. But hopefully Greg can answer a few of these questions. So there's some questions about the H-1B lottery case.
Well, I'm jumping off in 2 minutes. Chuck, I think, just actually lost his connection. That's the difference. I have to actually go in 2 minutes.
Any effect for day one CPT student as a plaintiff in the H-1B lawsuit? If you've already been approved for CPT status, I can't imagine any reason why being the plaintiff would impact that. As long as CPT is legit, right? As long as your CPT is legit and it actually meets the regulations, there couldn't be any impact.
Yeah, I mean, it's not because H-1Bs are another non-immigrant visa. You don't have any issues with like intent or anything like that when you're on CPT and you file for an H-1B. I don't see any bearing on one to the other.
And this one, for H-1B lottery case, will plaintiffs have priority to be selected? I think we have a clear answer to this, right? No. I mean, this doesn't mean
you guys will benefit if we are successful if we, if the numbers get put back into an H-1B lottery, but you're not going to be preferred for selection if they're out there. So it's overall your odds get better, but they're not going to be, you're not going to be jumping ahead of everybody else and getting those visas.
All right, let me see if there's anything else. Any other questions that you all see that need answers?
By the way, I think it's worth noting that because the odds are not, it's a lottery, but it's not like the Powerball, the H-1B lottery. You have in a general year, they're going to have typically a 1 in 2 or 1 in 3 chance of getting selected. So to the extent that the numbers are put back in and you weren't selected, you're still going to, you're going to have a 1 in 2 chance or 1 in 3 chance of getting one of those numbers that are put back in. So it's still pretty good.
This one has to do with eligibility for the EBAOS case, Greg. So this one, would dependent be eligible if the primary 485 receipt date is February 2021, originally filed October 2020?
I'm trying to make sure I understand the question here. So this is somebody who has filed an adjustment application and they filed for the dependent a little bit later, assuming that, okay. I'm just trying to understand how that
I think
happened.
that's right. Principal was filed October 2020. Dependent is filed February 2021.
Yeah, it still should be fine as far as participating in the case, even if it was not filed even if they were not filed contemporaneously. He's back.
There it is.
Sorry, my phone died. Sorry.
Well, I think you're just in time
I'm going to have to leave.
to check out, because I think we've answered all the questions that we have for today. So,
good.
Well, that's easy.
Thank you
That's
all
good.
for joining. Yeah, thank you all for joining, and we will see you all next week, same time, same place. But it won't
Monday next
Oh, yeah,
Monday.
We did this one on Tuesday because we had a holiday yesterday, but next week it will be on our YouTube channel, not the Joseph Hall page. So stay tuned.
Yeah,
Does it
Jeff,
conflict with
we'll move
annual
into that
Does it conflict with annual conference stuff? We have to also make sure that
Yeah,
I think we're okay.
Okay.
All right.
All right, y'all. Thanks so much.
Bye-bye.